Hi, everyone. Today, I will be talking about visiting Australia, and I will highlight several Australian visas the applicants may use to come for Australia for a variety of reasons. But first of all, let me introduce myself. My name is Yulia Moiseeva, and I'm a registered migration agent located on the Gold Coast, Queensland. So today, my session will be dedicated to visits for Australia. There are several visitor visas the applicants may consider. Let's begin with a quick overview. First of all, there are few visas that is relevant to a specific country of passport. For example, we have visitor visa, subclass 651, which is free to apply, and it's only for 36 countries, nationalities, where if you belong to any of these countries, you can make your application, bearing in mind that the applicant may satisfy financial criteria, health, and character. This visa will usually be granted in the blink of an eye or in several days, where the visa will be valid for up to 12 months, with an opportunity to stay in Australia for up to 3 months and multi-entry. The next type of visa is ETA 601. The cost to apply for this visa is only 20 Australian dollars, and it's available for 34 countries. So again, the same application. If you are a citizen of any of those eligible countries, you can make the application, and the application will be considered fairly quickly, and you will be able to enter Australia for up to 3 months, and you will have a duration of the visa for up to a year, multi-entry. The next type of visa is visitor visa, subclass 600. So for those who are not eligible for the visas I mentioned before, or still, if you are an applicant for 600 visa from any country all over the world, you will be able to access 3 streams. So first of all is a simple tourist stream. I will break it down a bit later, what's the purpose for this stream. The second stream is business stream, usually for those who are attending seminars, business meetings, etc. And third stream is a family-sponsored stream. So for those applicants who have already eligible relatives in Australia, and those eligible relatives are either permanent residents or Australian citizens, they may look at family-sponsored stream. Please bear in mind that boyfriend, friend, or New Zealand citizens will not be eligible to have this family-sponsored visa, and not to be eligible to be a sponsor. When we're talking about 600 visa, depending on the stream, you might have variety of options for duration of this visa. So 600 visa tourist stream, usually used for humble tourists, so for people who just want to come and visit Australia, have some sightseeing, spend any significant dates here, spend New Year here, and these people doesn't have any relatives or friends here. Or you may use 600 tourist stream visa, for example, when you're planning to enter study in Australia at a later stage, or you're planning to transfer your children to school to Australia, and you would like to explore the schools or have a school tour by yourself. In this case, that's a good idea to arrange tourist stream visa in order to then come to Australia, have a good look, explore your locations, explore schools in person, and then plan for the future. Another option why people are using tourist stream subclass 600 visa is where they are coming to visit friends, family, or prospective partners, or partners at the moment. So this type of visa can also be used for this purpose. Tourist visa are also used for exploratory visas, especially if you're planning your skilled migration, employer-sponsored visas, or business migration at any point or at any later stage, it's a good idea to plan your trip to Australia to investigate what state and territory will be the best fit for your family and best fit for your purpose. And then obviously have a look around, enjoy the Australian weathers, and have genuine exploratory visit. When we're talking about business stream visas, apart from attending any seminars or expos, these visas are widely used to arrange practical interviews and come to Australia. Please bear in mind, only the person who are going to attend and undergo practical interview will be granted business stream visa. If, for example, this person would like to come to Australia with a family, then it's wise to arrange only business stream visa for the main applicant who's going to be undergoing interview. And for the family members, you're simply arranging tourist visa stream because they're not going to be doing any business activities as such. The last stream is family-sponsored stream. These visas are usually used for people who are failing to satisfy criteria for tourist stream, as an example, or got refusal in the past based on GTE criteria. In this case, if this applicant has an eligible relative in Australia, it's maybe an opportunity to consider family-sponsored visa. Let's have a closer look what's happening with family-sponsored visas. These visas require not only a formal sponsorship from eligible relative who is in Australia, either as permanent resident or Australian citizen. It's also required financial bond from 5 to 15,000 Australian dollars. I've seen a scenario when department were giving an opportunity for $30,000 and $40,000 bond for applicants from specific countries. The reason for that is if the country has a long history and high rate of non-compliance and no return, even family-sponsored visa will not guarantee that the applicant will actually come to Australia. So please bear that in mind. And in case if this applicant will stay in Australia, the monetary bond that was given to department before the visa was granted will not be refunded. Also, the important thing to mention that family-sponsored visa will have mandatory no further stay condition where the applicant and holder of family-sponsored subclass 600 visa will not be able to make any further applications in Australia except very limited visas such as protection visas. So in this case, if you're planning ahead, and especially if you have a partner in Australia who you're aiming to visit, do not consider family-sponsored visa because it will have automatic and mandatory limitation and will not allow you to apply for any other visas from Australia. So the best visa to consider for partners or for parents will be tourist stream visa. Then depending on the country of passport and depending on the duration of stay, the applicants may be requested to undergo biometrics. And if you're asking for 6 months or 12 months stay on 600 visa, or if the applicant is over 75 years old, then the medicals will be automatically requested after lodgement. Please bear in mind that this visa has a government fee of $195 for current program year, and the consideration of this visa may take around 2 to 4 weeks. Sometimes it's more quicker, sometimes it's more longer, depends on the country, depends on the processing time per that specific embassy. When you're gonna get this visa, the most important thing is a compliance with the visa condition. And let's consider the scenario when you come into Australia and you have this visa granted for up to 3 months stay and up to 12 months duration, multi-entry. So how are you going to guess when you need to leave? My answer is fairly simple. We have the Vivo system. It is the online verification system from Department of Home Affairs, where I would strongly encourage applicants who already got 600 visa, and once you come to Australia, you can simply run a Vivo check, and the Vivo check will show you the last date on your current visa. So meaning your last date on 3 months window, where you will be able not to lose this date and either apply for any other visas you may be eligible for or leave the country in time. When we're going to be speaking how many visits the person will be permitted to do within a year of tourist visa duration, 3 months stay, multi-entry. My advice is the following. Do not use this visa for ongoing residency. So what does that mean? If, for example, you're coming to Australia, spending up to 3 months in Australia, then going in any nearest country for 2, 3, 5 days, and then quickly coming back and spending another pretty much full 3 months in Australia. On the second transition between any other country and back to Australia, you likely may be interviewed at the borders, and the border force may likely will be asking questions in regards to purpose of your stay, how you're maintaining yourself, and what's the reason why you keep traveling there and back in the country. So it's very important for you to understand that short visits is permitted, but if you're aiming to stay in Australia for longer, the visitor visa will not serve this purpose, and you need to consider what will be your next options. In regards to 600 visa, as I said, you can make your exploratory visa to come to Australia and explore schools for your children or vocational study, higher education for yourself or your children, or make any other arrangement. However, from the 1st of July 2024, under the legislation, it's no longer permitted to apply from visitor visa 600, 651 or 601 visa to student visa while in Australia. So bear that in mind, because that's relatively new and it is important. You will simply get invalid application after applying from those visas to student visa while in Australia. So don't do it, and plan your next move accordingly. In regards to processing of visitor visa and what are the main important documents, how you highlight your genuine stay. So visitor visa require applicant to describe their case as concisely as possible and provide all the documents at lodgement. The reason for that is department is aiming to process those visas fairly quickly, and there is no need for department to keep guessing what are the reasons of travel, whether the applicant has travel history, etc., funds, ties to home country. Simply, if case is not complete and if the department has some doubts, the best thing department will do is to refuse your visa, and you'll have to relodge the application again. Bear in mind, if you belong to the country where biometrics are required, for every next application, you will have to do biometrics every time again. So in terms of your highlights, why you need the visitor visa, there is quite a few highlighted area where you would like to explore and get as much evidence as possible. So first of all, humble is reasons why you are traveling to Australia. And in this case, you need to really consider the logic behind that, and the logic behind the screen when the officer will be looking at your case. So if your case is not full and complete, and if you didn't provide enough explanations why you need that type of visa, as I mentioned before, the department's officer is likely to refuse a visa rather than keep asking questions or requesting information. So it is in your best interest to prepare your case in full before you lodge the application. So reasoning is important. When you have any ties, say your friends or family, that's worth mentioning these people on the application and provide relative documents. There is a lot of discussion whether you will need to disclose your relationship when you are coming to visit your boyfriend or your partner. My answer is absolutely yes, because there is no legislative stop for the department to reject your visa simply because you're coming to visit your boyfriend or partner. Mind the reason when you have your case, but the reasoning why you're truly coming to Australia is unknown, or if you simply just mentioning your partner or fiancé, mentioning as a friend or mentioning as partner or fiancé, but there is no documents attached to the application. Again, it's going to be a lot of questions from department's officer, and in absence of any information or documents, the officer simply reject the case. If you're preparing your reasoning based on the fact that you are visiting your friend or relative, you need to establish the link between yourself and the relative, provide documents and evidence of status of your friend and relative in Australia. And it's also recommended to provide a little bit more information about this person in terms of their employment, financials, if they providing any support to you, and providing pretty detailed invitation from them describing why basically they're inviting you to Australia. And interesting fact is, when your friend, for example, is permanent resident or citizen with a good salary, good position, everything is fine, this person obtained their permanent residency through legit programs such as, for example, partner visa, skilled visa, etc. It's likely to work in your favor, but it's not going to guarantee that you will get the visa only because you got an invitation from a friend or family. On the other side, if your friend, for example, is on bridging visa, so waiting for some sort of refused application to be reviewed by AET, or if this friend already citizen, but they obtain their permanent residencies through refugee or humanitarian protection visa, that may potentially influence your application in a bad way. The reason for that is department has all the information about people who came to Australia and lodged the application in the system. And for example, if your friend has or had a situation where it was protection visa or any other multiple visas that will lead to permanent residency, or this person used to invite a lot of people who never returned from Australia, again, that can be biased by the officer towards your application. So be careful choosing who is going to be your inviter from Australia. In regards to the situation when you come into Australia and claiming your relationship with Australian citizen or temporary resident, as I said, that's absolutely fine to disclose those relationships. But again, you need to provide more documents about those relationships. And I recommend to provide not only ID documents for your partner and obviously a status of the visa, but I also recommend to provide information about your relationship in a short way, not the full case as if you would be providing this for partner visa. But it's logical where you provide some information, how you met, how your relationship developed, why you need to come to Australia now, for example, to meet friends and family. And for example, if your partner already exhausted all paid leave and he or she can't go overseas to meet with you, and hence it's going to be more logical and practical if you come over to Australia. So reasoning is very, very important. And again, the whole case, when you prepare the case, needs to be logically proved by documents. The other reason, one of the main reason to assess genuine temporary stay on visitor visa is ties to home country. There are two situations. First, when you are currently residing in your home country, passport country, and second situation, when you're residing in a third country, for example, on another visa. So when you're residing on your home country, there is no visa as such for you. So you're going to be providing your passport, and then you're going to be providing ties to your home country in the form of employment, which should be official, which should be paid, and there should be a logic, again, to seek paid leave, especially if you're going on holidays. For example, look at the situation where the applicant just started new employment a month ago, and they apply for visitor visa seeking up to 3 months stay. So it's absolutely logical, because once the person just started, no employer will provide paid leave that quick. An application is likely to be rejected. However, if, for example, you started a new position or you transferred to new title within the same company, in the visa application itself, you have only one line how you're going to describe your employment. And of course, you're going to be putting your absolute recent employment there. In this case, it's worth providing your full resume, indicating your full work experience, full work history, so the officer will understand that you have, for example, extensive work history, and hence it matches your savings history. In regards to other ties to home country, depending on your situation, and can be ownership of real estate or cars, motorbikes, anything, land. If you're not the owner of the real estate, you can provide long-term rental agreement. If you're traveling with family and kids, you may provide enrollment for the school for children and evidence of their school holidays. You may provide enrollment for yourself. If, for example, you are a student of university, or if you're finishing school, you would like to provide as much information as documents as possible. So if you're a business owner, you can provide ownership of your business, and if there will be anybody who will replace you during your holidays, you need to mention that. Then your situation, so whether you're in employment or whether you have somebody else sponsoring, supporting you. For example, if you're a student, your parents may support you, or if you're running the business, then all this situation and all documents needs to match your savings history as well. In this case, you will have to provide not only bank balance showing at this moment of time you have, I don't know, $20,000 to cover your trip. Department will be looking at the savings history and legitimacy of the funds. For example, if you've been in employment, it's worth showing recent taxation records or superannuation records, pay slips, that will correspond to your bank statement showing when exactly were you receiving your salary payments. For example, every month you can highlight it on your bank statement and show your recent history up to 3 months savings, for the officer to understand that, okay, it was legit funds, and then you had an opportunity to save those funds, and here you are, now you're showing these legit funds to cover your trip. Absolute minimum to show for 1 month of stay is 2,500 Australian dollars recommended. Of course, if you have somebody who will provide you with support in Australia, you may consider something less. But it's absolutely crucial and important to have access to your own funds. Reason for that, I'll give you a couple of scenarios. For example, you have a contact in Australia who is going to be providing their financials, their bank statement, and at the same time, invitation letter saying that they cover all your expenses, all your trip. At the same time, you as their friend or relative, we're not considering parents now, will be showing absolutely nothing. In this case, the officer may still consider refusal of your visitor visa. Reason for that is if anything goes wrong with your relationship with that person who invites you, you will have left with absolute no funds to cover your stay. And again, likely you may enter cash in hand employment that will be breaching your visa condition. So you need to be mindful, and you will have to have at least something on your bank account. So zero on the bank account will not work. In terms, if you are in the third country, so if you are applying to Australia, to come to Australia, and at the moment you are residing in third country, it is possible to apply from third country. However, the officers will be looking at the following. What's your visa in this particular country where you're applying from? So because you will have to indicate which country you're currently residing, and it's going to be your exact country of residency, not your passport country if you're residing in the third country. Then you will have to show your current visa in this country. And that's important because if, for example, your visa is expiring, say you have less than a month left on your visa, and obviously you may not have no ties in this country, then the department will be reluctant to consider visitor visa because you will unlikely be coming back. So in this case, if the visa that expires while you are in the third country can be extended, my advice would be to first extend this visa and then consider application for Australia. Then the department will be looking at your employment. And again, there are a lot of digital nomads all around the world at the moment who are working for one country, sitting in another country. And sometimes, obviously, the income will not be taxable. However, again, it's in your best interest to prepare your case logically. For example, you're sitting in one country, your employee is in the other country, and you're aiming to come to Australia for a short holiday. Then you still need to show your employment and savings history, your current visa. In terms of your employment, you may indicate in your reference letter that your employer is asking you to work from the certain time zone, for example, and they're aware that you go into Australia on a short leave. However, under your employment agreement or contract agreement, they will be waiting for you to come back. So to strengthen your case. Again, if you're sitting in the third country and you have at least long-term rent, again, if your kids are at school or you have a property, motorbike, dog, anyone else, anything else that's worth preparing all these documents to showcase your circumstances. And it should work. In regards to any other ties to home country, it can be your relatives. Sometimes people decide to leave kids in home country and then arrange the visitor visas for themselves. Then you need to explain why you're doing that and who will be minding your kids. If you have older relatives who will be relying on you, for example, your older parents, again, it's worth mentioning how you are connected. For example, if you're living in the same household, you're providing for them, you're looking after them, provide this information in your support letter. Provide any other documents that can confirm that, in order for the officer to know that that is your circumstances. Yes, you're allowing yourself to have a break, but again, at the same time, you're showing that you are going to be likely returning back home. The other important criteria the officer is going to be looking at is your travel history and your compliance with any other laws of any other country. And then in the majority of cases, of course, it's on you whether you are disclosing it or not. I would not recommend hiding the information, because depending on what country you ever applied and get a rejection or deportation or cancellation of the visa, department may investigate, and you will likely not only get the refusal but ban from reapplying to Australian visa. If you ever have any cancellation or refusal, it's worth mentioning the circumstances and mentioning that in your application. Then you will be given an opportunity to provide the documents and explanation. Again, depends on your circumstances. Take it seriously. Do not hide it, and provide the explanation what exactly happened in that circumstances, why you got the visa rejected or refused. Because we had these scenarios where we disclose everything freely, provided an explanation, and department granted the visa to the client. So there is no scenario when, if you have any refusals in the past, it means that you will never ever get any visa to Australia. So that's not the case, but it depends on your circumstances. Another important criteria for visitor visa is country specific. So this case and this circumstance you will not be able to overcome. But bear in mind, because depending on the country of your passport, depending on your surrounding circumstances, whether you have any genuine reason to visit Australia, or what exactly is happening, whether you have strong circumstances in your home country, the department can still be biased in regards to a specific country. For example, if the country overall has poor economic situation now, where there is a decline in employment, or if there is a country where a lot of people trying to claim asylum, coming to Australia, apply for protection, never return, or if this country specific has high non-compliance rate, all those circumstances may influence your particular case, even if your situation can be better than the average person from this country. So bear that in mind. We have a scenario where department declared in the refusal that the applicant has too much money, not too little, but too much. It was very biased, I believe. And as I said, if you prepare your case fully, it's also no guarantee that the application will be approved. If you prepare the case with your migration agent or lawyer, there is no guarantee that the case will be approved. So visitor visas are usually 50-50 cases. So there is no absolute logic sometimes in the decisions. However, another couple of things I would like to stress out. If by any chance your application is getting assessed, and as part of assessment you get request of so-called natural justice letter, bear in mind that this means that the department found some discrepancies, or for example, department might contact your workplace and received some contradictory information, or it may be simple innocent error in the documents. So natural justice letter usually indicates that there is some problem with the application. And with this letter, I'm taking every case cautiously, because if there is any true discrepancies which were genuine and you can explain those, in this case, it's safe to prepare the response for natural justice and prepare all the documents, and likely it may be overcome. Give you a scenario. For example, I had a client who prepared reference letter on the letterhead of a totally different company. The reason for that was that there was two companies sitting in one office, and simply it was human error. Everything was overlooked, and the official letterhead of another company was pretty much given to prepare a reference letter. We got the natural justice, but according to the documents, according to taxation records, everything was clean. It was just a human error. So we explained ourselves and got the visa. However, if you have a natural justice letter and you understand that, for example, you provided forged documents, which is absolute no-go, then you are likely to get not only rejection on the visitor visa, but also you may get the ban called 4020 for provision of misleading and false documents, and this will lead you to a 3-year ban overall. This ban can potentially be overcome if you have relatives or friends in Australia whose interest will be involved. But in this scenario, if you ever come across a natural justice letter, my first advice would be to get the proper advice to understand what's happening, whether you can justify it all. If not, my advice would be simply to withdraw the application, because if you withdraw the application, you will not receive any refusal and will not receive any ban. So that is very, very, very important. As I said, if you're going to be providing the documents to the department and preparing your case, financials are important. Reasoning why you're coming to Australia is important. Ties to home country is very important. Travel history and overall genuine temporary stay is important. So you need to explain yourself. And a lot of people are coming to me where I investigate their refusals. If you ever come across to refusal of visitor visa, please feel free to send me all the documents for assessment. I provide assessment free of charge for refusals to understand the reason and advise whether anything can be done, pretty much. It's an interesting situation for me because my office never aim for refusal, so we don't have a statistic, but I investigate each and every case for refusal with excitement to understand whether I can overcome any refusal matters and then can assist the client. So we had one of the recent cases we've done where the applicant was granted this ban for 4020, whether it was applicant's fault or agent's fault, but the fraudulent document was prepared and provided. After the ban was over, so 3 years was over, however, the department still have all the information in the system. And after 3 years, applicant requested another visitor visa. The applicant has a family in Australia who were permanent residents. However, the visitor visa was again rejected. So we took the case and got every single application, including notes from the officer and any surrounding documents and information from the department. And then we were investigating heavily what else can be done to strengthen the case. So it took us some time. However, there was a family of 2 adults and a child. And after 3 refusals and 1 ban, the family was finally granted visitor visas after big effort from my office. However, 1 adult still got the refusal with unknown reason. And my understanding is that sometimes the department may have some information on the file and you will not guess what the information can be. For example, it can be dobbing, it can be any third-party information about this particular client. So anything that may make the officer believe that you're not going to be returning or you likely will be breaking the law, the application still may be refused. Another case I would like to mention, when I investigated the refusal, I came across the person who was giving a lot of invitations to different people and they don't even know each other. And a lot of people who use this invitation never return from Australia. So another person whose case was pretty strong without any invitation as such, he requested this invitation from that person, and they were not even close of friends as such, but this invitation served differently, so shed the big black cloud on this application, and the client was rejected. And while we were investigating the reasons, it was noted that the person who was an inviter, in fact, used that method to invite a lot of people who apply for protection visas while onshore, and hence I believe that influenced the applicant case. So my bottom line for visitor visas: choose your reasoning carefully, choose your inviter carefully, and basically understand why you're coming to Australia, why you need it, and put these arguments in writing for the officer to also have the valid reason, basically, why you need to come to Australia. So I would like to attend a few questions I have prior submitted, and then I will attend the chat. So if you would like to put any questions, please put it in the chat. I will attend the questions I have in hands, and then I'll return to the chat. So let's have a look. What do we have here? So first of all, the person lives in France and in the third country, and she will be applying from the third country. So her bank cannot provide bank statement in English, and payslips are also not in English. The question is whether the bank statement and payslips can be translated by herself. So the short answer, it can be done this way, but please bear in mind that every single document you apply, you provide with your application for visitor visa must be in English if the original is not in English. And the format of providing the documents, you need to provide colored scan of your original document and official translation into English. Official translation does not mean that you have to use native translators, not at all. You can use the local translators, and at least I would recommend to use local translators with stamp and letterhead to translate your personal documents. For very lengthy documents like superannuation summary, pay slips, or bank statement, you potentially can get your own translations. It's not that it will be the only reason why department may refuse your case. However, please be mindful that if department will not like it, the case still may be refused. So my idea to use official translators. It does not need to be translators from Australia only. Right. The other question is about visitor visa for mother, and pretty much 3 years visa, up to 12 months stay, and up to 12 months out of 18 months condition. So usually how it works, the parent can stay up to 12 months in any 18 months period. So the safest plan would be to come to Australia for 11 months and nearly coming to 12 months time, then leave Australia for 6 months, and then come again for another nearly a year. So in this case, you will nearly use 3 years on your visa. So in this case, you use 2 out of 3 years in total for stay in Australia, which is pretty good, I think. Right. In other question is, can I come on a visitor visa and study English? Yes, you can use your absolute normal tourist visa to come to Australia and say, come for holidays and at the same time study English. So you don't have to pre-book any college or courses, because the visitor visa allows you to study up to 3 months in total. So not up to 3 months every 3 months, but 3 months in total for the duration of the visa. In this case, if the visa is granted, you can come to Australia, basically walk in any college, start the English course, and then bear in mind that you have 3 months to study formally. The other question from that applicant is whether she can switch this visitor visa into student visa. It used to be a case. I'm reminding them from the 1st of July 2024, it's not the case any longer. So you cannot lodge a valid student visa from visitor visa while you're in Australia. So you can lodge, for example, student visa offshore while you have your visitor visa, and then you can come to Australia and be on your visitor visa and seek bridging visa associated with student visas lodged before you come to Australia on the visitor visa. So that works. Another question will be, is it possible that my office can assist with tourist visa? Yes, my office is able to assist with tourist visa. We even have a free assessment form on our website, where you can jump on my website, yuliamoiseeva.com.au, and pretty much pre-assess your case to understand whether you have any risks. It will based on your employment, country of your passport, where are you at the moment, and what are the surrounding circumstances of your trip. So do not lose this opportunity to give us some information in order to get some at least pre-assessment feedback. And then if you would like our office to take your case, please feel free to request our pricing again through our website. So another question from the chat. Hi, Yulia. Had a refusal from student visa 6 years ago. After I went to UK to get master done, traveled a little bit. If I apply for PR or skilled worker visa, does my previous visa refusal affect? For PR or skilled workers visa, from my memory, there is no question as such about refusals. But if you're going to be requested to provide certain additional forms, for example, Form 80, then you will have to disclose your refusals. And simple refusal based on the fact that the department didn't believe that you will be coming back home will not affect. Please do not forget that if you ever have a refusal, for example, for Australia visa or any other visa, but mainly for Australia, when you lodge another application, firstly, you will have to strengthen your case, and you will have to make sure that it's either some time passed or your circumstances change a little bit, because simply relodging application with the same story, the same documents will not achieve anything. You will lose time and money and get most probably another refusal. However, there is no statutory limitation or timing when you can relodge your application, and it all depends on your circumstances. However, if you're going to be relodging, do not forget to indicate that you happen to have refusal in the past, because I had the scenarios when I saw people simply forgot to indicate that they had refusal in the past for Australian visa. An Australian department treated it as misleading information, where person got not only a refusal but ban as well. So be careful with that. Another question from the chat. Can you please tell me about migration to Australia permanent with family? I strongly recommend you to rewatch a few of my live streams from the previous weeks, where I spoke specifically about skill migration in one of my streams and employed sponsored visa in another. So there are at least 2 streams, 1 hour each. So you will have a lot of information there as a starting point. And then if you would like our assistance, please feel free to reach out. Thank you very much for listening to today and participating in my live. I wish you all the best day, night, and evening, wherever you are. See you soon. Thank you.